Hi, I'm Jonathan Sparks with Sparks Law, where we offer creative legal ideas that spark the entrepreneurial fire. This is our video series on what does the expert business lawyer do for his own business. Today, we're going to be talking about my employment contracts. Employment contracts need a number of things. One, they usually need to be tied to a handbook as well, so that the handbook can be updated from time to time. This has things like vacation time policies, sick days policies, and a bunch of legalese writing that really does need to be in there. And if you're worried about yours, send it to me and we'll check it out for you. There's a handy link right here. Another thing is what we call restrictive covenants. These are different for every employment situation. Some of them, they make a lot of sense. Some employees, if they're at the reception or something, it might not make sense to restrict their ability to compete with your business or company with a competitor. So let's talk about each one of these. The first, and the big kind of elephant in the room, is the non-compete agreement. This, within a specified geographic region for a specific time, usually less than 2 years after the date that they leave the company or are terminated, and for a specific type of industry that they're working for, they are restricted place, time, scope of work that they're doing from working for your competitors or starting their own competing business against you, which might be a big problem. The other one that we have is the non-solicitation agreement. This sometimes works in practice similar to a non-compete agreement, but it's actually quite different. A non-solicitation agreement prevents them from soliciting your clients, your customers for businesses. For us, it's our clients. For other people, it prevents them from soliciting their other employees for work, or even their vendors for work with a competing business. If you can imagine, someone might be hired by a competitor and to find out sort of your business operations and your favorite vendors and how you can price things so that you have an edge over your competitors. Another provision in the restrictive covenants series is a non-disclosure agreement, or NDA. The NDA protects your confidential information, so that includes your customer lists. It includes my client list. And it prevents them, again, from utilizing that list and taking it to a competitor or disclosing it to a third party. You have a right to a lawsuit against them if they do that and they sign one of these employment contracts. And the fourth in the restrictive covenants area is called a non-disparagement clause, which basically means that they can't disparage you with things like negative public reviews on social media and the like. So that's about it. I'm Jonathan Sparks with Sparks Law. Smart business decisions start with Sparks.